Welcome to This Week in Education Law, School Administrator's Guide, episode number 6. Each week, I share up-to-date court decisions on education law. I pay special attention to the court decisions and arguments related to school administrators' daily work. Today, I focus on a case about public school employees' privilege to make defamatory statements. Here is the question. Do public employees have an absolute privilege to make defamatory statements in the exercise of official duties? Here is some background of the case. Thomas Lowell provided piano tuning services to Medford School District and assisted in producing concerts performed in the school facilities. When he was providing production assistance for a concert, Lowell noticed an echo near the stage and complained to the school theater technician, Stephanie Malone. Later, Lowell felt that Malone had not adequately responded, so he followed up with her. Malone reported to her supervisor, Bales, that Lowell appeared to be intoxicated and he smelled of alcohol, and that this was not the first time. Bales repeated Malone's statements to Armstrong, a district support services assistant. Armstrong sent emails summarizing Malone's statements to 3 other district employees, including the supervisor of purchasing. Armstrong expressed concerns that appearing on district property under the influence of alcohol violated district policy and the terms of the piano tuning contract. Lowell filed a defamation lawsuit against the school theater technician, Malone, Malone's supervisor, Bales, and the district support services assistant, Armstrong, alleging that the statements about his intoxication on the school district property was defamatory. The school district argued that because the 3 accused people were public employees, they were entitled to an absolute privilege for defamatory statements made in the course and scope of their employment. Moreover, because the school district employees were entitled to that absolute privilege, the school district, too, was immune from liability. But Lowell argued that the 3 accused employees were not entitled to immunity because they were low-level employees performing ministerial tasks who were not entitled to an absolute privilege. The trial court agreed with the school district that the alleged defamatory statements were made by public officials in the course of their official duties, and they were entitled to absolute privilege. Lowell appealed. The circuit court affirmed, holding that an employee of an executive agency has an absolute privilege to make defamatory statements in the exercise of official duties, even if the statements were malicious and the people who made the statements is a lower-level employee. But the Supreme Court of Oregon reversed the circuit court's decision and remanded the case to the circuit court for further proceedings. What is absolute privilege exactly? Absolute privilege is an ancient doctrine. It was long recognized by English law as a means to protect the freedom of speech and deliberation in Parliament. The absolute privilege was later embodied in the U.S. Constitution. People with absolute privilege enjoy certain freedoms for communication. Statements that are considered absolute privileged cannot serve as a basis for defamation under any circumstances. Why are certain communications protected by the absolute privilege? It is based on the sound public policy that some communications are so socially important that the full and unrestricted exchange of information requires some latitude for mistake. There are 3 types of absolute privilege. legislative absolute privilege, judicial absolute privilege, and absolute privilege for other acts of states. In the course of legislative proceedings, a congressman can say horrible things about another congressman, and those statements are absolutely privileged. Even though those statements are horrible, but they're not acceptable as the basis for defamation under any situation because they are protected by the absolute privilege. The purpose of the absolute privilege is to allow legislators to enjoy an uninhibited range of freedom to propose, oppose, debate, adopt, or reject ideas as precursors to legislative action. An example of judicial absolute privilege is statements made in courts. Communications by witnesses are also protected by the absolute privilege. They are never going to be subjected to a defamation claim. The third type of the absolute privilege applies to the executive branch of the government, including police and administrators. But executive branch employees were not traditionally afforded the same broad and absolute immunity granted to employees in the legislative and judicial branches. When applied to speech in the executive branch, the absolute privilege was confined to official communications from the heads of departments, in which the head of the department spoke for the government or as its mouthpiece. Most states retain a narrow conception of the executive branch privilege and apply it only to the high-ranking government officials. In K-12 school settings, statements made by superintendents and school board members during formal judicial and administrative proceedings have been protected by the absolute privilege. For example, the North Dakota Supreme Court held that two school board members' statements about a supervisor for transportation and food service were protected by the absolute privilege. So the supervisor had no basis for defamation. School board meetings are recognized as official proceedings authorized by law. So school board members' statements were related to matters before the school board. Those statements were made in the course of discussion about the school district's transportation program following the submission of a transportation budget for the next school year. So school board members had legitimate interest in the district's transportation program, and they had a right to inquire about and comment upon all aspects of the program. But even statements made by superintendents and school board members were protected selectively by the absolute privilege. The application of an absolute privilege for defamatory statements were very limited. The Court of Appeals of the State of New York wrote, unless an official is a principal executive of state or local government, or is entrusted by law with administrative or executive policymaking responsibilities of considerable dimension, policy considerations do not require that he be given an absolute license to defame. The privilege exists to protect those who bear the greatest burdens of government, or those to whose official functioning it is essential that they be insulated from the harassment and financial hazards that may accompany suits for damages by the victims of even malicious libels or slanders. This at least serves a recognized public purpose. But to cloak public officials who do not have such a need with the privilege to wrongfully vilify others with impunity, while their critics remain fully liable for their own tortious communication, would tend to squelch criticism of government by its citizens while serving no sufficiently countervailing public purpose. After all, the immunity is intended for the welfare of the public, not for the government employees. as the Kentucky Court of Appeals said in 1910, when it refused to extend the absolute privilege to a school superintendent. It would be a dangerous and vicious thing to license people to write and speak without restraint. There are many evil-minded and recklessly disposed who would shelter if they could under the protection afforded by absolute privilege and give free bridle to tongue and pen to injure or destroy an enemy. It would place in the power of vengeful and unscrupulous persons the right to malign at will those who had incurred their displeasure, and allow the traducer to scatter without stint scandalous and defamatory matter about all who might come within the circle of his amity. This doesn't mean that public officials do not have privilege at all. They are entitled to qualified privilege. The difference between the absolute privilege and qualified privilege rests in the role of malice. Malice means personal spite or ill will, culpable recklessness or negligence. A qualified privilege is one that is available only in the absence of malice, while an absolute privilege, a veritable immunity, is impervious to proof and therefore to a charge of malice. In one case, a faculty member sued the vice president for academic affairs at his college, alleging that the vice president's communication with the tenure committee was defamatory. In a tenure committee meeting about the faculty member's qualifications for tenure, the vice president read a letter which accused the faculty member, who was a married man, of having attempted to seduce a young woman who was a student in one of his classes. The letter was written by an unnamed author, and the accusation in the letter was never verified, even though the letter had arrived at the college months earlier. The faculty member had never seen the letter, heard it read, or been afforded the opportunity to do so. The Court of Appeals of the State of New York noted that the vice president of the college, who was also the acting president in the absence of the president, had no absolute privilege because the state university's decision-making process was vested in its trustees and chancellors. They were the ones who were entitled to the absolute privilege. One justice wrote, "It is difficult to perceive how the goal of protecting our highest administrative, judicial, and legislative officials from undue harassment is advanced by extending the salutary doctrine of absolute privilege to all presidents of public colleges." Some state courts that have been asked to extend an absolute privilege to lower-level executive branch speakers have decided that a qualified privilege was sufficiently protective. In one case, the court refused to extend absolute privilege to police officers and stating that the police should never act with malice or ill will against the citizens of the state without being called to account for their actions, and a qualified privilege will sufficiently insulate police officers and ensure the vigorous enforcement of the law. In this case, the Supreme Court of Oregon disagreed with the school district's argument that the absolute privilege can be extended to all public employees who make defamatory statements in the course of performing their duties, including those who do so with malice, without upsetting the balance of competing interests on which the absolute privilege rests. The court refused to extend the absolute privilege to all public employees acting within the course and scope of their duties. So if you are an employee in public schools, your statements are most likely not entitled to the absolute privilege. Just because you work for the government doesn't mean you can make statements and spread rumors that damage someone's reputation for your personal spite. If someone makes an accusation of another person, you cannot relay the accusation to others without verifying it. If the accusation is rumor or known to you or others to be false or has been discredited, you have an obligation to communicate it in a way not to mislead others. If the accusation is true, then that person whose reputation is at stake should at least be given an opportunity to respond to it. I hope this case is helpful for your work as administrators. I'll see you next week in This Week in Education Law, School Administrator's Guide.